Senator Blackburn.
Thank you, Mr. Chairman, and to each of you, thank you for being here today. And I know others have talked about what this hearing really appears to be about today, and I think that the reason is pretty simple, and it is that we have some who disagree with the court's recent decisions. That's why we've had all this talk about reforming the court and packing the court, and it is because we have some that do not like those decisions. And, you know, Mr. Chairman, there's a witness on this panel today who said that the court's legitimacy depended on how the justices ruled in the presidential immunity case. So we get it. We know what's going on here. And we also know that it is imperative that the court be recognized and supported as an independent and co-equal branch of our government. And hearings like this are just more of an attempt to delegitimize the court and the work of the court. And despite some of my colleagues' scare tactics, those of us on this side of the aisle will continue to protect the court's independence. Ms. Mascott, I want to come to you, if I may. Let's talk about what is going on in the court right now. There was the leak of the Dobbs draft opinion, and of course we know that led to near constant protest outside of the Supreme Court justices' homes, death threats, even an assassination attempt. And last week there was a memo from Chief Justice Roberts that was leaked to the public, and then there was an account of the justice's private conversation after an oral argument that was made public, as well as other internal deliberations. This is frightening to a lot of people. And I know that you clerked for Justice Thomas, so talk a moment about the impact that these leaks have on the public trust of the court and on the institution as a whole.
Yes, Senator Blackburn. Well, first of all, these leaks are just deeply unusual and outside of any long understood norm of civility. And as you point out, it seems like at times they're motivated to be able to potentially lead to mistrust in the branch, attacks on what the branch is doing, but also the person who's doing the leak being able to frame the story, as potentially in the case with the New York Times getting presumably selected documents handed to it. And they also violate deep-seated norms of confidentiality, not just within the judiciary itself and the justice and the clerk relationship, but just in general, the legal responsibility to have confidentiality with clients for deliberative decision-making. And it's just a well-understood duty that we have. And so it's very troubling, as you point out.
Let me ask you this. Do you think these are deliberate attempts to persuade justices or influence their decision-making process?
It's certainly hard to know the motivation of the leakers. As you point out, what it led to, particularly in the leak of the Dobbs opinion, was something even far more serious, which is threats on the life of the justices. Thankfully, though, it seems as though any attempt to influence the justices was turned away because the final opinion in Dobbs was strikingly similar, I think, word for word to the leaked opinion.
Let me ask you about that. I found it so interesting. Section 1507 of Title 18 makes it illegal to protest outside of a judge's residence with the intent of influencing that judge's decision. And after the Dobbs leak, and when the justices were facing this intimidation, despite that, the DOJ has refused to enforce Section 1507. And I have introduced the Protecting Our Supreme Court Justices Act, which increases the jail time for anyone who tries to influence a judge's decision. So what more can we be doing to allow Supreme Court justices to do their jobs without fear of safety for themselves and their family?
Well, I think protecting confidentiality, I think trying to accurately characterize what the justices are doing, having respect for a co-equal branch. But then also I think the courts decisions in recent years and just being cognizant of trying to make sure it's carrying out its proper role within our system has helped as well, because there needs to be less pressure put on the court as the answer for all changes in society, which, if I can just make one final point, I think is one reason why this idea of criminally prosecuting a president is so far outside the norm of the entire constitutional structure, because it's again turning to the courts and the judicial system to try to effectuate change and threaten and attack, what's really supposed to be left in many cases to the political process.
Okay, thank you. Thank you, Mr. Chairman.